and welcome to our channel. In today's video, we are going to talk about divorce and its implication on your immigration application. My name is Marilyn Quintana. I'm a regulated Canadian immigration consultant and Director of Operations at eVisa Immigration. Our mission is to bring valuable tips and updates regarding Canadian immigration and assist you to become a successful immigrant in Canada. But before we begin, please do not forget to give us a thumbs up, subscribe to our channel, and click on the little bell right below this video so you can receive weekly notifications of our new videos. Going through a divorce is never easy, but going through a divorce in Canada while applying for immigration and far from your family and loved ones can be even more challenging. And this divorce can affect your plans to immigrate to Canada. That's why we decided to make this video so you can have information on how a divorce can impact your immigration plan. Therefore, it is very important for you to be well informed, take the correct measures, and avoid mistakes on your immigration application. First, we are going to talk about divorce while you are here as a couple, one is studying and one working. In most cases, the work permit of the spouse won't be affected and will continue to be valid until its expiry date. However, if you are the party that has the work permit, you may not be able to extend your work permit unless you take measures to apply for permanent residency. Applying for permanent residency can secure you the ability to apply for a work permit extension so you can continue working in Canada. In a situation that you are a spouse of a work permit holder, the same applies, which means in most cases your work permit will remain valid until its expiry date. However, you won't be able to extend if you are no longer married and if you're not the main applicant. Now let's talk about divorce when you are applying for permanent residency through Express Entry. If your divorce happens after you create the profile but before the application is submitted, you must update the profile and the person that's not the main applicant will be removed from the application. In this case, it is important for the party that's being removed to seek alternatives to create and start an immigration plan by themselves, no longer as a dependent family member. If your application for permanent residency has already been submitted through any of the economic immigration pathways, including, for example, Express Entry or provincial nominee programs or even business immigration, you need to inform right away that there were a change in the marital status of the applicants. In this case, the main applicant will remain in the application and will be able to finalize it. However, the party that was not the main applicant, meaning the dependent family member, will be removed from the application and in the same way must seek options to immigrate through themselves. Any change in marital status must be informed to IRCC at any time until the landing. Not informing IRCC of a change of marital status can be very serious because any information that you withhold that may change the officer decisions is considered misrepresentation, and a misrepresentation can render all the family members inadmissible. So in case of misrepresentation, your application may be refused, but not only that, you and your family members may also be banned from applying for a certain period of time. Now let's talk about divorce or separation when you are applying for spousal sponsorship. If the decision of your application is not yet being made, your application will be cancelled because you are required to continue to be married in order to complete your application. However, if you decided to separate or divorce after permanent residency is granted to the sponsored spouse, it is important to have in mind that the sponsor will continue to be responsible for the sponsored spouse for a period of 3 years. And during the period of responsibility, also known as undertaking, the sponsor cannot sponsor another spouse. If you were the sponsored spouse that immigrated to Canada through the spousal sponsorship program and later divorced, It is also important to mention that you are not going to be able to sponsor a second spouse unless a period of 5 years has passed. Now let's talk about divorce after becoming permanent residents, but before applying for citizenship. Generally speaking, each person will apply for citizenship separated, so it does not matter if they divorce after obtaining permanent residency together. We understand that every situation is different and every couple is different as well. We also understand that there are differences between common law couples and married couples, and the advice that we will give you on your specific case may vary. If you need assistance to understand what's the best course of action on your case, you can count on us. You can schedule a consultation to discuss further your case with us. The information to book a consultation is down below this video. eVisa Group can assist you with all the steps that you need to make Canada your home. We can assist you with education, visa, immigration, citizenship, and also career consulting. I hope you guys enjoyed this video. Thanks for watching and see you next time.